Hello and welcome to Tangents from Coin Center. I'm Jerry Brito, Executive Director of Coin Center. And with me, as always, is Peter Van Valkenburg, Director of Research of Coin Center. Hi.
Greetings, avid Tangents listeners.
I mean, the fact that we haven't put out episodes of this august podcast with any regularity doesn't mean that we don't have regular viewers.
And the one listening after a multi-month hiatus are the avid listeners.
There you go. There you go. I think we are innovating in the medium. If we don't have something to say, we don't say it.
I don't know. That might be what you're doing. I'm having a second child. His name is Otis, and he's adorable.
All right. Peter, today, as people might be surmising, perhaps from the title of the episode, we will be discussing the recent decision in SEC versus Ripple, which has provoked a lot of discussion, a lot of hand-wringing, a lot of interpretation, et cetera, et cetera.
As it should.
As it should, absolutely.
As you've been saying, especially you, me as well, for years, it's really great to finally have judge-made law in an area that has a common law character to it, a lot of good judge-made securities law, and finally have something to read.
That's right. Which is not to say that we haven't in the past, right? So this judge very astutely cites the Telegram case, the library case, the kick case. So what we're seeing, though, is the development of a common law interpretation of the statute. And what I think shocked people here is that this case came out the other way. In that, you're right.
I mean, Telegram was an emergency injunction against a distribution. But really all Telegram was about these sales that had happened in advance of Telegram's launch.
My point is,
yeah. We'll get into all that.
It didn't come out as an unmitigated win for the SEC.
Yes,
and so now people are like, wait a minute. But I think visible from the fact that the judge cited all these previous cases, it was that this Judge Torres, was able to distinguish those cases and, in fact, use them as support for her analysis. And so we get basically a ruling that says that the XRP token itself is not a security, but that it can be the subject of a securities offering, which just sounds very familiar to me, Peter. Who's been saying that for about, I don't know, like 8-9 years?
I mean, okay. I've said it, Jerry. Were you hoping for you? You've said it?
I was hoping for a we.
We?
Coin Center, perhaps.
Coin Center has said it. Yeah. And, before we move on to that, just to undergird the point you were just making, I feel like this isn't some crazy judge out of left field. This is the Southern District of New York. This is, the same Court of Appeals, federal court area as Telegram, as Kick. Like, this is part of a lineage. And so, there's a lot of people out there who are rightly saying, hey, this is just a district court opinion. Don't pay attention. It's going to get appealed. It could all change. But that's always true of a district court opinion. They can be appealed. If there's, legal issues still at stake.
They will be appealed.
And it will be appealed. But this is not like some crazy town where we just got lucky with some strange judge in some obscure part of the country or something like that. Which, by the way, that would be good law too. But that's not what's going on here. Like, this is interesting. Yeah.
Right. Okay. So what we're going to do is we're going to analyze the holding, basically, of the opinion of the case, and we're also going to address some of what I think has been just misreadings of what the judge has been saying that we've seen. On Twitter or on the popular press, et cetera. So one thing I think the way to begin is to begin by understanding what the judge was ruling on here. The judge was ruling on here on summary judgment.
Cross motions for summary.
Cross motions of summary judgment, which means that both parties to the case petitioned for summary judgment. And so what is summary judgment? Summary judgment, and Peter, you're close to this more than I am these days. But summary judgment is when all of the facts are basically not in dispute. The parties agrees to what happened, right?
Even in the view of the facts most favorable to the other party, right, they have not cited a claim for where relief is warranted. And so you should just give us judgment on the...
Right. And so the question is just a question of law. The judge here is just saying, look, you guys don't dispute about the facts. I just have to determine what the law is and apply it to the facts that you guys don't dispute. And that's what the judge did here. And as we begin, what I want to do is draw people's attention to two statements that the judge lays out as fact in the fact section of the opinion, which I don't think people have focused on, but I think they're kind of crucial. So here's the first statement. Quote, "The founders did not sell any XRP before the launch of the XRP ledger, and Ripple never owned the 20 billion XRP retained by the three founders." That's one statement. The other statement is, quote, "The XRP ledger is based on open source software. Anyone can use the ledger, submit transactions, host a node to contribute to the validation of transactions, propose changes to the source code, or develop applications that run on the ledger." Quote, close quote. So I'll ask you again, what does that remind you of?
So it reminds me of our 2016 paper, which we were drafting in 2015 and actually doing some outreach to the SEC in PowerPoint presentations about, on securities regulation in the cryptocurrency space.
And how to interpret Howey.
And how to interpret Howey, specifically things like the third prong, efforts of others, where we said, look, decentralization, as we talk about it in the community, is not a legal term. It's not. But some of these fact patterns are relevant to a determination of whether people are relying on the efforts of a third-party promoter for the value of their investment. And we should think about these things. Now, no, we never came up with what we would call a decentralization test or anything like that, anything elaborate about, say, like subsequently, lots of people said, like, well, what about the number of nodes on the network? Like, should be an objective test based on like actual empirical facts in the world, or the concentration of ownership on the network, things like that.
What is the governance like? What are the tokenomics like, et cetera?
Right. All we said back in 2016, and I still think it's the approach, and it's echoed in those two statements of fact in the Judge Torres's opinion, is, look, if it's a pre-sale, i.e., someone's collecting money from people who are interested in this network, but the network doesn't exist yet, it can't be quote unquote decentralized. And the inverse of that is to use the legal term, which is to say you're definitely reliant on those persons' efforts to build the network because it doesn't even exist yet. Someone has to write the open source software. Someone has to write the protocol. Someone has to run the software. This is all yet to happen. And then the other thing we said is, look, it needs to actually be an open, permissionless blockchain. And that means the software is open source. Anyone can change it, edit it, copy it, distribute it. And the mechanism for updating the ledger should be open protocol or open consensus mechanism, which we've explained in lots of different places is either proof of work or proof of stake. Ripple's actually interesting because I've referred to it sometimes as social consensus because it's got this, like, there's a list of valid validators, but anyone can change that list. But anyway, this notion that there should be some way for a third party unrelated to the project thus far can just enter the network and be an equal participant on that network, depending on how much effort they're going to put in, whether it's proof of work or proof of stake or, these sorts of things. But it's just you don't need to ask permission. It's just, you just join and you do the thing that gets you the right to do stuff on the network. And
so the reason to bring out those facts, stated as fact in this opinion, is that the opinion, the decision she makes, the holding she delivers, is predicated on those facts, right? And so you have to take for granted, as the judge did here, and the parties seem to have, right, that XRP did not do a pre-sale, and number two, XRP is open and decentralized, for lack of a better word, right?
Yep.
And so you have to take that as granted to then read the rest of the opinion.
Right.
If you have issues with that, You think that's not a fact? Well, you might, if you don't think that's true, you might come to a different conclusion.
Yeah.
About the law, about the application of the law. But in this case, at the very top, those two things are established as fact. So for purposes of this, the four corners of this opinion, it's a fact. And it's important, right? Because as you say, if there wasn't a presale, and if the thing is open where anybody can use it, anybody can run, people have incentives to buy tokens to consume to use on the network for their own purposes, et cetera. That presents a whole different idea of what an investment of money is, expectation of profits, et cetera.
Yeah, and from a policy standpoint, it's the most relevant fact. Like you might want to also know, how many nodes are on the network and a lot of other things to know the security of the network, to know a lot of other things about the network. But from a justiciable, actually like trying to find good public policy standpoint, that's the one that matters. When we were writing that paper, I kept thinking back to antitrust law, which I'm by no means an expert in, but there's this notion, more of an economics notion of antitrust, where we're not necessarily looking for a competitive market. We're looking for a contestable market. Like, are there barriers to new competitors entering the market? And if there are no real barriers, if anyone can enter the market, then we're going to assume that the existing competitors in the market, even if there's only one or two of them, are not going to behave badly vis-a-vis their customers. They're not going to exploit them because they know that this new entrant will just come in and challenge them right away. And so in the crypto context, look, yeah, you might have a situation where there's only a handful of validators on the network, but they're behaving well. And, as long as more validators can enter if they need to, like, to me, that is what we should hope for from a public policy standpoint as to what a decentralized network is. It's just one where there isn't somebody by fiat, by permissioned control saying, I run this. Because if you're doing that, then you're maintaining an Oracle database. And you're probably also, if you're selling a bunch of stuff that's described in that Oracle database that you have full control over, then you're probably issuing some sort of secured interest or some security or something like that.
And and we should just mention about Oracle database, you mean Oracle Incorporated, like the company.
Yeah. The old ledger technology versus decentralized ledger tech. Yeah.
Okay, so good. We established that. So let's get back to the meat of the matter. We've said for years that there is a distinction to be made between a token and a securities offering.
That's right.
And even if you can have a token that is the subject of a securities offering, but it's a thing in its own, that it in itself is not a security. And Judge Torres here basically employs the same logic and analysis that we've been saying for years is a correct way to apply the law. And so if you will permit me now, I am going to quote from the opinion. And I'm sorry, folks, but I'm going to be doing a lot of this because I think it's important. So here is from the opinion, quote, Howey and its progeny have held that a variety of tangible and intangible assets can serve as the subject of an investment contract. See, for example, Howey, orange groves, Glenn Anderson, whiskey casks, Edwards, payphones, Hawking versus Dubois, condominiums, Continental Marketing, Beavers.
I love that Beavers was in there.
Yeah.
That's my favorite case.
And then the one I love the most, SEC versus Telegram, digital tokens.
Yeah.
Okay. So because in that case, okay, well, let me just continue reading from the quote. In each of these cases, the subject of the investment contract was a standalone commodity, which was not itself inherently an investment contract. For instance, in the original citrus groves in Howey were later resold, those resales may or may not constitute investment contracts, depending on the totality of the circumstances surrounding the latter transaction. Okay, it's like we could have written this ourselves.
But the land is not a security. I love that. I mean, I shouldn't be surprised. She's a judge in a fancy district too. But I love that she stated that correctly, because some people out there say like, "Oh, the oranges are not securities." Like, no, the contract wasn't for a sale of oranges; it was for a sale of orange groves. Land is not securities. We could postulate a contract where it was for a sale of oranges, and actually, the Beavers is that. The Beavers were not securities.
Yep. And so again, this is now going back to the facts that we laid out before. This is easy. What I just stated is easy to understand, given if you take the facts as facts. This is easy because the token is a commodity, right? It's open. Anybody can get on the network and use it, right? It's not something that is issued and dependent on any party.
It's hard though.
Yeah, it's hard to understand, but yes.
It's hard for people in the financial world, I think.
Yeah.
Because the financial world has no history of like highly liquid markets in investment contracts, as in that subset of a securities.
Mm-hmm.
Like there aren't a bunch of weird Florida land deals that involve the service contract to pick fruit and sell it at market that are trading on the NASDAQ. And so to people who are enmeshed in the world of finance, I think you think a security is a security. Like they're just securities. I don't understand these things that are not securities except under certain manner of sale conditions. And that's what we're talking about in the investment contract analysis. Right. If I say, hey, fur hats are coming back in style, Jerry, you're going to want some beaver fur to make your fur hat. I've got a bunch of beavers. Do you want to buy a beaver? I know you don't want to take care of a beaver because they pee and they poo and you got to make
up to that point. If I say, yes, I want the beaver, and you give me immediate delivery of the beaver.
I show up with a cage. It's got the big teeth. It's cute. Yeah.
Not
a security.
Maybe clearly not a security. But go on. But then you say,
if I say, well, I know you don't want to raise this beaver. I happen to have this lovely beaver farm full of beavers, and I'm going to put yours in a special pen. That one's yours. The other ones aren't yours. I'm going to feed it really good food. I'm going to mate it. You're going to get all the fur from that beaver when it passes, sadly, and its children's fur. And I'll just take care of that all for you. So here's a contract about the beaver maintenance, and here's a contract about you have title to the beaver. But this is not a security. You're not owning a share of my beaver ranch. You're just buying the beaver and signing a contract for maintenance. This is a weird contract. And traditionally, and this is why the Howey case is weird, investment contracts are weird. But they have a big body of law, and this opinion is completely in line with the past body of investment contracts law. It's true that people who trade in traditional securities look at all this and think that's all weird, but it goes back to the 70s, to the 60s, to the 50s. I think W.J. Howey versus SEC is 57, if I'm not wrong. Like this has been established for a while.
Okay, I'm going to keep quoting here. Sorry, there's going to be a lot of this. Quote, even if XRP exhibits certain characteristics of a commodity or a currency, it may nonetheless be offered or sold as an investment contract.
Yep.
As another court in this district recently held, while helpful as a shorthand reference, the security in this case is not simply the digital token, the gram, so she's quoting Telegram, which is little more than an alphanumeric cryptographic sequence. This case represents a, quote, scheme, end quote, to be evaluated under the Howey that consists of the full set of contract expectations and understandings centered on the sales and distribution of gram. Howey requires an examination of the entirety of the parties' understandings and expectations, citing Telegram. Let me just finish. XRP, as a digital token, is not in and of itself a, quote, contract, transaction, or scheme, end quote, that embodies the Howey test requirements of an investment contract. So she is citing Telegram, right? A seminal digital, asset SEC case before the Second Circuit or before SDNY for the same thing, for the proposition that you have to separate out token itself from the sale, scheme, contract, offer, the kind of thing that can be a security.
Right? And this is interesting because I don't remember if we did a tangents episode on Telegram. I think we might have. Maybe not. And I know that we had some reservations about Telegram. And so you might be thinking, well, why would we be happy about this decision that references this past decision that we were unhappy with? And so just to recap what Telegram was an emergency injunction sought by the SEC to stop the distribution of grams to the general public through the Telegram app, right? And specifically what the SEC was alleging is, look, we've got this sale of grams to these big-time investors that was evidenced by contracts and negotiation, and it has all the manner of sale qualities of an investment contract.
And I think maybe
it's not just you picking up the beaver from my beaver farm and owning it. It's a bunch of other stuff, like I'll hold the beavers for this long, lockup provisions, if you will. I'll feed them. I'll take care of them. all these things that I'm doing as the seller to create indicia of expectation of profits. Now, what the SEC then said, though, and this might remain sort of the controversial part, is that the planned distribution to the public merged with that original sale to big investors. And those big investors actually weren't purchasers of a security. They were underwriters of a long sale that happened over a matter of months, if not years, that ultimately was intended, even if it didn't look like it, to be a sale from the promoters to the general public through the investors, which were underwriters. But this still doesn't mean that grams are securities. This just means that the SEC said the investment contract hopped over the VCs or the other big investors who made that first purchase, and was actually just one big contract from the promoters to the general public. So the security was this investment contract to the general public through the investors, not the grams themselves. I don't think I did not disagree with that at the time. I think it's probably right.
I don't take an opinion. I don't have an opinion on that, or maybe I do, but I'm not going to say what my opinion is about that. But I will say that even if that case was correctly decided and they were underwriters, et cetera, it can be distinguished from this case because, pointing back to the facts that we laid out at the very beginning, there was no pre-sale here.
Yeah.
Okay. What we have here are a bunch of tokens owned by the company Ripple that are tokens that operate on a completely decentralized network. Mm-hmm. So there were no, right? So the promises at issue here are not about the creation of a network that you're making to investors and then you're going to launder those tokens to the general public. These are commodities owned by a company that were sold in one instance to the general public and in another instance to investors along with promises.
Yep. Promises, lockups, a lot of lawyering and agreements and things like that.
Correct. So
you don't even need, I mean, you're right. They're distinguishable because Telegram was a pre-sale and the Ripple sales were, as stated in the fact pattern, after the Ripple network was live. But you also don't need to distinguish because the two decisions are not in conflict with each other with respect to sales to institutional persons. And we haven't gone over the general holding for the case. We're assuming that, if you're listening to Tangents, you've already read 50,000 takes on Twitter. But in a nutshell, sales to institutional buyers were deemed to be securities because they were commodities sold in a manner of sale as an investment contract. And then programmatic, so the judge calls them programmatic sales, just selling them through an exchange, like in a typical order book situation, were deemed to not be securities sales. And so the Telegram case was all about these sales to these institutional buyers who were then treated as underwriters, ultimately expecting to sell to the general public in one single big monolithic sale. That aspect of the Telegram opinion is completely impossible with the institutional buyers in the Ripple case being found to be buyers of a security, buyers of an investment contract.
Yeah, and I think and we'll get to this in a little bit, but I think it's unfortunate that the judge here chose the specific labels of institutional purchases and programmatic purchases, or institutional sales and programmatic sales, to refer to these two categories. She could have picked any label in the world.
Yeah.
She chose those two labels, and I think that has caused some confusion because people think, well, if it's about who you are, what your position is in the world. Oh, so if I'm an institutional buyer, then I have certain protections from the SEC. But if I'm a mere retail buyer, like a mom and pop, then I don't have these protections.
Sounds like a classic inversion of the public policy rationale for securities law, which is to protect mom and pop and say that the hedge fund can go do what it wants because it's a sophisticated investor. Money on its own.
What is this SDNY judge thinking, right? Yeah. Like, of course, she understands what the public policy of the securities laws are.
And no such inversion exists here because it's not about the buyer. It's not about being an institutional buyer versus being just a buyer on an exchange through the quote unquote programmatic sales. It's about the intent of the seller and what they put the buyer on notice of by their manner of sale. We can't go into the world and know what's in the head of everybody who buys corn at the grocery store. We can know that sometimes somebody stands in front of the grocery store and says, yeah, you could buy corn in there, or you could come over here and look, I've got this cornfield. I'll give you a huge discount on the future of all this corn. You're going to pay me up front. Like, then it starts to become a securities offering because now I've got all these additional promises about what I'm going to do with my cornfield. It's about what that person puts into the mind of the buyer. And so, not to
So,
Judge Torres's choice, it's just her choice of word. We agree with the holding, but the labels are confusing because it really should have been about manner of sale to institutional buyers. It really should have been about an investment contract, a commodity plus other promises, versus manner of sale to the programmatic buyers, which is just selling a commodity with no other warranties to those buyers. In fact, not even knowledge of who those buyers might be, in which case we can't say that you're putting those people on notice of your efforts.
I would say I don't think you could have labeled the category investment contracts because that would have been a tautology, right?
Yes.
These are investment contracts because they're
investment contracts where there were investment contracts.
But ideally, it would have been better to see. I think it would. I think you would have avoided some confusion in the lay public if you had chosen labels something like contingent sales and non-contingent sales, right? So
that's what I mean. Is it's the
I know you mean that
analysis, but it's the manner of sale as to what the seller does, not who the buyer is. So it's not institutional versus regular.
Yeah.
It's manner of sale. Commodity sold with promises. Yeah. Oh, that's an investment contract. Commodity sold with no promises. That's not an investment contract.
Commodity sold at arm's length to an unknown party.
Yep.
Not a security. Not an investment contract. Speaking of that, here is the holding related to the programmatic sales. Having considered the economic reality of the programmatic sales, the court concludes that the undisputed record does not establish the third Howey prong. Whereas the institutional buyers reasonably expected that Ripple would use the capital it received from its sales to improve the XRP ecosystem and thereby increase the price of XRP. And then she cites KIC, SEC versus KIC or KIC versus SEC. Mm-hmm. Programmatic buyers could not reasonably expect the same. Indeed, Ripple's programmatic sales were blind bid-ask transactions, and programmatic buyers could not have known if their payments of money went to Ripple or any other seller of XRP. What was I going to say about that? So one thing that I think is interesting, just to point out, is that she's saying, having considered the economic reality of programmatic sales, the court concludes that the undisputed record does not establish the Howey prong test. And as she says throughout the thing, she repeats several times, there's no evidence that the programmatic buyers knew anything, et cetera, et cetera. The SEC could show evidence.
Hold on.
Yeah.
Pause. She does say the test is not what was in the mind of the buyers.
Yeah.
It is what the seller intended to create in the mind of the buyers. It is what did they, it's sort of an estoppel argument. Like if Ripple had gone out and said to a bunch of the general public, buy Ripple, we're going to make it go to the moon. And then they'd gone on an exchange and bought it. Maybe you'd have those are the facts the SEC has to show.
Yes, but you would have to show two things. You'd have to show statements by Ripple to that effect.
Yep.
And I think the SEC does put into evidence a bunch of statements that were made at public conferences, et cetera, that could be argued to be statements to the public. Mm-hmm. So I think the SEC shows something like that. But then the SEC also has to show that somebody acted on this and there was some meeting of the mind there, right?
Yeah, a contract,
shall we say? Even though the judge rejects the need for a contract as an
essential perfunctory step to the Howey test,
correct,
which is fair. We don't necessarily need more steps to the Howey test, but the judge is reading a lot of that into step
in here. Yeah. So the point is that the SEC isn't showing, and by the way, she says the programmatic sales were, am I reading this right? Were 1% of all Ripple sales, something like that. So
yeah, but no. So Ripple being the seller,
yes,
in the programmatic sale was only 1% of all the sales of Ripple happening on these platforms. Right. And her point here, and it's a very good point, and I'm presuming that Ripple's lawyers argued this point, or maybe she just picked up on her own. I'm not sure. But the point here is, if you just go to Coinbase and buy Ripple, there's a 1% chance over the entire life of all sales of Ripple on Coinbase that you actually bought it from the company. You bought XRP from Ripple because the company was selling on Coinbase or was selling on similar bid-ask exchanges. But most of the time you were buying from just somebody else who owned Ripple, And so there's this question of like how could we assume there to be some sort of quasi-contractual. Obviously, there's no contractual relationship in a typical like market, order for something. There's no like obvious. You just have bids and asks. You don't even know who your counterparty is, and it's the processes of the exchange that ensure that your interests are protected. But even a quasi contract, like it doesn't make sense if most of the time you're actually going to be buying from like Joe Schmo who has Ripple, and you don't know the difference of buying from him versus buying from Ripple itself, who has XRP. Sorry.
Okay, so so we think that the decision is broadly speaking correct, and we'll get to some other parts of it in a minute that I'm not so sure are correct. Or
do you want to talk about the third part of the holding?
I'm going to get to that.
Okay.
I'm going to get to that because you're talking about the other distributions.
Yeah.
Let's get to that in a minute because I have questions about that. I'm not as settled on that.
No, I do too. We didn't plan this.
We didn't plan this.
Oh, interesting.
As usual, violent agreement. So anyhow, so we think the decision is broadly speaking correct. Uses the right analysis, gets to the right conclusion given the facts that were taken for granted. Now, there's been a lot of different takes out there in the world. A lot of people seem to be confused by this opinion, or at least think that it it is confusing. So people we respect. So, for example, Matt Levine, Bloomberg columnist, somebody who I respect very much, and I'm a regular reader of his column, and I find it, and usually he is like spot on,
and also hilarious. The WeWork one, I still pull up and read for a laugh.
The which one?
The WeWork one.
Yeah. He is usually like very spot on about what is going on in the crypto space, and cuts through the BS and gets right to the quick of it. And so, but I read his column on this, and I was a little surprised. That it didn't seem to be clicking, and so I wanted. I'm sorry to be picking on him. I don't mean to be picking on him, but I think he is the best person to stand in for all the confusion that I saw on Twitter and in the press.
Ladies and gentlemen, please welcome Matt Levine. Sorry, Matt. We're going to just talk about you.
I mean, he's welcome to come here anytime.
Yeah, that's true.
And we'll be happy to have him on and discuss this stuff. So one thing before I just, because you were talking about buying on the open market and not knowing who you're buying from. One thing he does, and the way he begins his column, is by describing Meta stock. So Meta, aka Facebook stock. And he says, well, the way Meta is structured, when you have a share of Meta, you do not have any governance rights, because the way Zuckerberg set up the structure of the corporation, he has basically all of the decision rights. And also, Facebook or Meta has never paid a dividend, as far I think is what he said. So when you have a share, you don't expect to ever get any dividend or any stream. Maybe if Meta is acquired, you'll get something from that. But Meta,
or if they went bankrupt, if they got wound down, you are a creditor in bankruptcy. Like, you have an ownership right.
100%. But his point being that that's not, Meta's probably not going to go bankrupt, and Meta is not going to be acquired because it's like one of the 5 largest companies in the world. So it's not going to get acquired either. And so when you buy a stock of a share of Meta, he's saying, well, you don't have any governance rights, you don't expect anything, but you still get the benefit of disclosures from the company that they're required to be doing, et cetera. And the analogy here is, okay, well, now we come to XRP, and you have XRP where you don't expect anything from Ripple. You can't govern the Ripple company with a share of XRP. The same as Meta, but I mean, this is like a weird analogy to me. And it's a weird analogy to me for a couple of reasons. Number one, he chose the weirdest stock you could pick on the entire stock exchange. Most shares of stock do give you voting rights, do give you dividends, etc. But also, it's distinguishable because at the end of the day, it's a security. It's a stock.
Yeah.
It's a different thing from an investment contract.
Well, I think what he was driving at, maybe in that you don't get voting rights, you don't get a dividend, is that it's not a security. But the fact is, you still have legal rights against the issuer. And therefore, the issuer is required to make certain disclosures before people put their money down to buy those legal rights.
Correct.
And even though Facebook is weird, I'm sorry, I sometimes refuse to call it Meta. But even though Meta is weird, you still have legal right. It was a legal. It was a security that was issued. It was, you have part ownership in this corporation, and you can't just pretend that doesn't exist to make a point. Yeah.
Correct. And if his point is that the policy that governs stock issuance should be the same kind of policy of investor protection as to investment contracts, he's right. It is. And there's nothing in this case that upsets that. And so to that point, I'll say, let me see, hold on, where is it? I'll ask you this question, Peter. Does this decision mean that sophisticated parties get protection, but unsophisticated retail market participants don't? And I'll quote Levine here. Quote, this is Levine speaking, quote, if you go around making public statements on your website and on Reddit and elsewhere, saying things like, quote, if you buy our token, we will use the money to build an ecosystem and make the token more valuable, quote, end quote, that makes your token a security, but only to people who are sophisticated enough to read your website. Sophisticated institutional investors who read your disclosures documents and understand that they are making an investment in your business are entitled to the protections of securities laws, while random retail day traders who just like your ticker symbol are not. You cannot be doing securities fraud on them because they are not paying attention. So that's Levine.
Yeah,
I've got a couple of things to say about this, but you go first.
Well, this is what we were saying earlier. This is not a holding, and this holding is just reflecting the ground principles of securities laws, nor are securities laws architected to create this sort of inversion of investor protection where we protect the institutional buyers and we let the lay public just, sink or swim. That's not what's going on here. What's going on here is people get protection when they're in contracts with issuers, when they've actually been induced to rely and then have relied on the promises of the issuer. And all the court is saying here is, look, we have to cut off liability somewhere just to have an efficient, market, to have an efficient legal system. And the place where securities laws historically have cut off liability is where there really is no direct inducement and contract between the buyer and seller, where really all the buyer has done is buy something from some third party or from someone else at an arm's length transaction that isn't actually a legal instrument, that isn't actually a stock certificate or something like that. And so the people who are getting protected in the Ripple case are the people who did buy a legal instrument. They signed, a probably very lengthy agreement. I haven't looked at it myself, with lockups, with choice of law provisions, with other warranties. These are the so-called institutional buyers. It's not that we're protecting them because we perversely want to protect rich institutional people and not the lay public. It's we're protecting them simply because they actually were induced to rely on promises by Ripple. And so when we can point to that, we can actually have securities laws come in and say, yes, we're here to protect you.
So that, and in addition to that, I think he gives away his confusion when he says that if you go around making public statements, that makes your token a security, but only if you do it to sophisticated people and not. When he says makes your token a security, he is, betraying the fact that he sees what the institutional buyers purchased and what the retail buyers purchased as equivalent, right? As the same thing, and they are not the same thing. The token is not a security. The retail buyers, they bought XRP. The institutional buyers bought an investment contract with a bunch of stipulations, including the delivery of some XRP.
Yeah.
These are not equivalent.
Yeah.
So it's not as if we're treating one thing differently than the other, depending on who is at the other end of the bargain. It's that these are two different bargains. One is subject to securities laws, one is not. And by the way, the ones that are not are subject to fraud, tort,
yes,
other things. So it's not like there's no recourse. And the other thing, here's a wacko analogy I try to come up with. Try it out on you. Suppose that I own a gold mine. Okay, and gold, everybody understands is a commodity, right? Mm-hmm. Gold bars are not securities. And there is a market for gold, right? And it's a liquid market, et cetera. But I own this big, and let's say it's a big deposit, right? I own this gold mine, and in addition to owning the gold mine, I also am a physicist that is working on a way to basically create cold fusion using gold or something, right? I'm going to make gold the input into a process that creates unlimited energy, right? So it's going to be very valuable. And of course, if I am able to do this, the value of gold everywhere is going to go up.
Mm-hmm.
The gold, in order to finance my project, I sell gold that I mine for my gold company. I do it in two ways. Number one, I sell it on the open market on an arm's length transaction to people I don't even know. Mm-hmm. The other thing I do is that I tell investors about my scheme, and I say, buy some gold because I'm building this thing. If you buy gold from me, I'm going to use that money to create my process and have unlimited energy, et cetera, et cetera.
Mm-hmm.
I think Matt Levine would agree that gold is never a security. And that example should be analogous to the XRP thing, right? Again, if the facts that we laid out at the beginning are right, because gold is different from a token. But go on. Sorry, what do you think about that analogy?
No, I think it's good. It reminds me of something I've said before about like if Henry Ford had been even more conniving and figured out even stranger ways to make money. Like, what if you are Henry Ford? You've got this idea to mass produce the automobile and change the way everybody, moves around the world. Huge, world-changing, very profitable idea. You say, but my business model is not going to be to sell cars. I'm going to give away the cars. I'm just going to give them away, put them out in the world. And before people realize how great cars are, I'm going to speculate about oil. I'm just going to buy up a shit ton of oil. And maybe I'm even going to bring other people in on this and be like, you're going to help me buy up most of the oil in the world. And people are like, oil? What are you really into lamps or something? Like, we have whales for that, dude. Like, why should we? And you say, well, I'm working on the automobile. So if you give me some money to help buy up more oil, we're going to have a lot of oil. And once this invention, the automobile, works, this oil is going to be way more valuable. That person bought a security from you. They bought oil through you, but they also bought your promise to make oil more valuable by inventing the automobile, distributing it widely, and creating or inducing a high demand for oil. Somebody who's just buying oil, though, is just buying oil. It's still just oil.
Yep.
Even if they're buying with the expectation that, hey, I see more people driving cars these days, I think this oil is going to be valuable. If you didn't go to that person directly and put that idea in their head and say, you can rely on me in order to make this future happen and your oil be more valuable, it doesn't. It's your mere idea that oil is going to go up in value because you saw somebody else inventing the automobile. It doesn't make oil a security.
Yep. And Levine also kind of focuses on the fact that the judge points out that when people were buying XRP on the markets, they didn't know if Ripple was on the other end of that transaction. And forgive me if I'm misreading him, but I think he takes that to mean that if you sell anonymously, then you can get away with securities crimes, right? And no, it's just that knowing who you're giving the money to is an indicia of what you want to accomplish with the purchase.
Right? Knowing who is going to give you the money and who you're giving the token to is an essential component of having some sort of actual contract or quasi-contract with that person.
Right. Sure. But even if you don't put the contract, even putting the contract piece aside.
Mm-hmm.
Right?
I don't know, though. I think that's actually so maybe we found some area where we slightly disagreed or differentiated in our reading. I read Judge Torres's third prong analysis as we can go beyond mere contract, because there's lots of quasi-contract cases in the Howey progeny, but we need at least some sort of quasi-contract where the parties have to have some knowledge of each other and be stopped by the other party's behavior. And the point of when you buy Ripple on Coin or XRP on Coinbase, you don't even know if you're buying it from Ripple or buying it from Tom or buying it from whoever, is this statement that, like, look, we can't even say that because Ripple was selling XRP on Coinbase, they somehow has stopped you and made you expect them to work on your behalf, because you didn't even know you were buying it from them. You just wanted to buy some of this thing. Again, like in the Henry Ford oil example, you might know that Henry Ford is out there making the automobile awesome, and so you say, I'm going to buy a bunch of oil. But that doesn't mean that there's a quasi-contract between you and Henry Ford. Like, that would be we could invent an investor protection regime that worked that way. But I would posit to you that that would be a horrible state of affairs where no one was ever able to do anything novel or unique in the world for fear of creating in the minds of the general public some expectation that some random shit in the world like oil is going to suddenly be valuable. And if that value doesn't materialize, you can then sue Henry Ford.
Right.
Like, it's insane. But yeah.
Okay. So let's move on to where I think, and again, we didn't plan this ahead of time, but it sounds like maybe we both had our heads tilted to the side a little bit when we got to this part of the opinion, and that is when she talks about other distributions, right? So Ripple sold to investors. They sold to investors investment contracts.
Yep.
They sold to the market commodity XRP, and then lastly they had other distributions, and these other distributions were to employees and enticements for
the ecosystem. Yeah.
And so this is what the judge says, quote, the other distributions do not satisfy Howey's first prong that there be an investment of money as part of the transaction or scheme. Howey requires a showing that the investors, quote, provided the capital, end quote, quote, put up their money, quote, provided cash, et cetera. Mm-hmm. In every case, finding an investment contract, a purchaser gave up some tangible and definable consideration in return for an interest that had substantially the characteristics of a security. Here, the record shows that the recipients of the other distributions did not pay money or, quote, some tangible and definable consideration, end quote, to Ripple.
It's interesting.
To the contrary, Ripple paid XRP to the employees and the companies. And as a factual matter, there is no evidence that, quote, Ripple funded its projects by transferring XRP to third parties and then having them sell XRP, which is something that the SEC had alleged, because Ripple never received the payments from these XRP distributions.
That's the underwriter argument. That's more complicated. We don't need to deal with that.
Yeah. And I think that's probably right, the way she put it there. We can kind of put it to the side.
I think so.
But so I mean, if you work for CoinCenter and CoinCenter pays you in coin, would you say that you're not providing any consideration?
Sure, you've seen the quality of my work.
Yeah, that's true.
It is not even a peppercorn of consideration. This is clearly you're just a benefactor. You just like me and you want to make me rich. This is exactly what also made my head kind of go like so. And so, like, from my perspective, like, so just in case people haven't like read in on what we're mind melding about right now, it's like employees providing labor to Ripple does seem to be some sort of valuable consideration. So why is it just an investment of cash? An investment of money? Why wouldn't we read investment of money more broadly to include any kind of valuable consideration, including labor, favors, other things, And so here's what I immediately thought. I thought, oh, cool. We're going to get the airdrop ruling in the Ripple case, which is a surprise to me because I've been waiting for an airdrop ruling for a long time. And so to unpack that, Lots of projects do airdrops. They say like anyone with a Bitcoin address is going to be able to, get some of this new token because they already have the private key that matches that Bitcoin address. And so we're just going to give out new token in pro rata shares to how many Bitcoins people have, and people will be able to spend them. It's a cool distribution scheme to try to get crypto out to a larger population without actually engaging in any sales. You could say that this is some sort of way around securities law if you were a sort of a more conspiratorial minded, or you can say this is actually just a fair way to distribute a token to a large group of people because you actually want the token to be decentralized and you want lots of people to have sort of interest in it and not have them rely on your efforts, which once they give you money, it's sort of like now I'm on the hook to them. I just want to distribute it out there and people will use it and we'll see what happens. So that's airdrops. And there, I think, the SEC has made some fairly loud noises about airdrops because they've been somewhat expansionist about their jurisdiction. There's no doubt about that lately. And they've said, hey, look at the stock giveaways in the 1990s. We wrote some letters of no action. We denied no action in some cases where .com companies were saying, visit our website and you'll get shares of XYZ.com, of pets.com or something like that. And the SEC said back then, look, even asking your purchasers of your recipients of your gratuitous giveaways of stock to visit your website and put in your email address, and often it was like share with 5 friends or things like that. Even that action of them visiting the website and sharing the URL with 5 friends is valuable consideration, which would qualify as part of a contract for sale of securities. Now, what's interesting about that, so the SEC says airdrops are probably securities sales because the stock giveaways were too, actually is very similar to what we were just discussing in the contrast of like, let's use Meta stock as an example versus XRP. Well, the problem here is that those shares of .com startups that were being given away if you visited their website were already securities. They were equity shares of a legal corporation. And when you purchased them, you obtained ownership rights to the corporation. That's what a shareholder is. And in airdrops, they are not. We need to first find the thing that's given away to be a security. And so then we need to actually do the Howey analysis. So the SEC didn't have to do the Howey analysis with respect to the stock giveaways in the 90s because the thing was a security. Here, you have to do the Howey analysis, which means you have to satisfy the first prong, which is investment of money. And at that point, you could say, well, wait a minute, is really just visiting a website investment of money? No. And so I've been waiting for this kind of holding from a court for a long time. Someone would have to come with the right claim as a plaintiff, and they'd have to argue well. But then this would be a pretty, I think, good, fairly uncontroversial holding, because merely having a Bitcoin address doesn't mean I gave valuable consideration to the person that airdropped Litecoin onto me or something. Like Litecoin wasn't an airdrop, but you know what I mean. Now here, there's a color. I think there is I don't mean to like ask for more securities regulation in our space, but I do think there is probably a colorable argument that there is some sort of investment going on. And I would have expected the judge to probe that and give some sort of like deeper factual analysis as to why this was not sufficient to satisfy the first prong. But the holding basically says there is no investment of cash. Now, maybe the whole lineage of cases says the only thing you can do is buy with cash. But
I would have to go look at the case law, and that's what we have you for. So we'll do that maybe some other time. But again, just reading the little bits of the precedents that she cites International Brotherhood of Teamsters versus Daniel. Mm-hmm. And she cites it, quote, in every case finding an investment contract, the purchaser gave up some tangible and definable consideration in return for an interest that substantially had a characteristic of a security. That doesn't say cash. That says tangible and definable consideration, to which I would say that labor would be that. And so to me, it's not about, so I think she may have quite accidentally reached the right outcome, but it's not because of the first prong. It's because, as you say, you have to do the analysis, and I would have to go look at the employee contracts of each person. Because, again, if I'm a gold mine and I hire you to work on my gold mine, and I say, I will pay you in gold. You work, your weekly wages will be delivered to you in gold, and you give me labor, I give you gold. That's not a security. However, if I say I'm going to give you gold because of and all these other, but you can't spend it, and you have all these other parts of the contract, then it may well be a security.
Yeah, and interestingly, it might be. This is something I don't know, and maybe a securities lawyer would have a quick answer to this. So if you do, write in the comments, like and subscribe. No, call me or email me at peter@coincenter.org. But it's probably somewhat moot, though.
Yeah,
because and I don't know that I'm not an expert in traditional securities law by any means. I think you could do distributions to employees of your company. Generally speaking, and that is not something that's subject to sort of a registration requirement or some other affirmative duty on your part as the issuer to go to the SEC and announce and get regulated in a certain way. And so even if the distributions to employees or the giveaways to third parties were themselves investment contracts, because we do find that the tangible consideration offered in return for them, even though it wasn't cash, was sufficiently tangible, valuable consideration, then it might still not trigger any kind of like failure to perform some duty on the part of the issuer, because gratuitous giveaways might not trigger much. I don't know. That's an interesting question. Then that little dangling thing that we said push aside, the underwriter thing, is this actually just a way to distribute to the general public through a unified sale, and the employee is actually an underwriter in this case, or the recipient of a giveaway is an underwriter with an expectation that they'd sell it to the general public? And here, I think Judge Torres is completely right. It's ridiculous to call, like, if I just give a bunch of stuff away with the tacit expectation that those people are going to then sell them to the general public, and with the money that they get from that sale to the general public, they're going to reimburse me through some non-clear way that I never contracted for. Like, that's a ridiculous way to be an underwriter. And I just don't think you could legally find that person to be an underwriter, nor would public policy argue that we should find that person to be an underwriter to protect the quote unquote investors who are the general public in that sale. But that's a whole other thing.
Yeah. And so the bottom line is that while we think that directionally she got the right outcome, we think it's weird, and I wouldn't be surprised if she might be reversed on that little piece.
I don't know.
About whether there was an investment of money here. That is all we have. I hope this helps folks. It's always way better for me and Peter to just kind of chat about this in 1 hour, almost on the dot, rather than try to write out our thoughts. It's a lot quicker. So hopefully this was useful to folks. Any parting words?
It's sending ripples through the ecosphere, Jerry. In this case.
Fantastic.
It's the best I could do.
All right. We'll see you all next time. Bye, Peter.
Bye, Jerry.